Lori Daybell, yet again, wants a new trial in Arizona. Let's see what she's got to say. Lori Daybell requests the court grant her a new trial. This motion is filed pursuant to the protections provided by Rule 24.1 of the Arizona Rules of Criminal Procedure. The Fifth Amendment Due Process Clause, Sixth Amendment Confrontation Clause, and the 14th Amendment of the United States Constitution, and Article 2, 4, and 24 of the Arizona State Constitution. This motion is accompanied by the following memorandum of points and authorities. Let's begin with the facts here. Fourth Amendment violation medical evaluation. On Friday, May 30th, the defendant became ill, vomiting at the lunch break during jury selection. After lunch break, the defendant informed the judge and state of her sickness, and that her investigator had been sick since the prior day with the same symptoms. The court asked defendant to stay for 10 minutes while he informs jurors and releases people with scheduling conflicts. Defendant was reluctant and did not want to vomit in front of jury. However, the judge refused to dismiss her. The 10 minutes turned into 1.5 hours. Before being dismissed by the court, he advised defendant to let court know through her team before Monday if she was still sick on Sunday, June 1st. Defendant was still sick and had her advisory counsel email the court to inform that she was still too sick with a virus and could not proceed on Monday, June 2nd. This is going to get really interesting because we have, from what it appears, no reason she couldn't be in the trial found by medical professionals. I can't wait to see how she swings that. Monday, June 2nd, 2025, defendant was very sick and had advised the court in a timely manner. However, the court sent an order to the jail on June 2nd, 2025 to have defendant brought to court by any means necessary. By the way, the any means necessary was in fact sent to the jail multiple times because they did not trust she would show up willingly. Defendant could not walk from being weak and dehydrated, having vomited all weekend. This is when she was in the wheelchair and then claimed she couldn't even sit in a normal chair. It had to be in a wheelchair. MCSO brought defendant to court in a wheelchair. Defendant then explained to the court that she was too sick to represent herself and would not go forward. The court again asked the defendant to stay while he brought in potential jurors to explain and ordered her out of the wheelchair and into a regular chair. Defendant argued that the last time he said 10 minutes, which took over 1.5 hours, so he dismissed her prior to dismissing the jury. Defendant was then left in the wheelchair in a holding cell with no blanket, medicine, or hydration for 6 hours waiting for transport back to the jail. What did she expect? Did she think that she was going to get a special bus back to the jail? On Monday, June 2nd, 2025, the court sent an order to MCSO requesting they medically evaluate defendant, a violation of this defendant's Fourth Amendment rights and Arizona. So, hold up. She is going to argue getting a medical evaluation while she tries to delay a conspiracy to commit first-degree murder trial is a violation of her rights. That's where we're at. All right, okay. Constitution, Article Section 2, 8, June 3rd, 2025, MCSO called defendant out of bed, again, to walk down to medical. Thought she couldn't walk. Oh, wait. She wasn't that sick. MCSO ordered CHS to evaluate the defendant's health without her knowledge. For anyone that didn't watch the trial, highly recommend you watch it, or at least you watch my coverage of it. She kept trying to get the judge removed in this case. When she failed to get him removed, she tried to get the other judge that decided to not remove him removed. Like, she was trying everything to stop this trial. And that's the exact same time frame she's playing these games. MCSO ordered CHS to evaluate defendant's health without her knowledge. Without her knowledge. I'm really interested how they did this without her knowing. CHS then provided their evaluation to the court through MCAO's civil attorney, Joseph Vigil, which was a HIPAA violation. Notice filed on June 3rd, 2025, initially not under seal. So, the logic she wants us to use is that she got called out of bed to go down to medical for a health evaluation that was without her knowledge, but she would obviously know about it once at medical, right? And then it's a HIPAA violation to tell the court, or is she saying it's a HIPAA violation because it was filed not under seal? I will say I haven't seen anyone post her medical records, right? So I'm assuming she's wrong about it being out there not under seal. Maybe she the chance she doesn't know the process, right? I find it weird that this whole argument here. I want to know. I want to know what wasn't under seal. That's what I want to know. On Wednesday, June 4th, 2025, this court ordered again defendant to court by any means necessary. Order. Yeah, so this happened a lot. They weren't letting her get away with not going to trial. To MCSO. Any means necessary order means guards show up at your cell and pull you out of bed and take you to court against your will. Not if you got up and got ready like you were supposed to. Once in court, defendant again informs the judge she cannot proceed because she is too ill. Judge Vareski orders her to not only to stay, but to defendant herself. Should we defend? While too sick to do so. Defendant was then forced by the court to voir dire the jury and select a jury. Thursday, June 5th, 2025, although defendant was still suffering from a viral illness, she was expected by Judge Vareski to give her opening statement and begin cross-examining witnesses. Friday, June 6th, Judge Vareski ordered defendant by any means necessary again defend herself sick in a full day of courtroom from 9:30 a.m. to 4:30 p.m. Now, mind you, this is because they found that she had no reason she couldn't be there. And also, the judge pointed out on the record that when out of the presence of the jury, she acted just normal and fine and was laughing and talking. And then when the jury was there, she kind of put on an act. Pointing that out. Sunday, June 8, 2025, Defendant's Advisory Council again emailed the court the defendant is still sick and she had been notified by CHS that the results of the testing performed came back with an infection in need of antibiotics for treatment. Yet again, any means necessary order was entered by the court for Monday, June 9th. So she's saying it was a viral infection. Okay. Monday, June 9th, 2025, Judge Vareski cleared the courtroom. Okay, so this is where he cleared everything. We get to find out what happened. She's going to spill it. And sealed the hearing now that there was actual evidence that the defendant had really been sick the whole time without treatment. In the end, Judge Vareski still ordered defendant to defend herself at trial, knowing she was too ill to proceed. I mean, if you're not going to give any specifics, they're going to get to see it if they're going to be looking at this motion, right? Like, they're going to get to see what happened in that courtroom, so they're going to know if you're full of shit. But I think part of this is performative for the media, for you, for me. She wants attention. There's no more trials left. I mean, there's not much she can do, right? Unless they did another murder and they never got caught for it and they're going to accidentally spill. Her time in the spotlight is done unless her appeals win. The by any means necessary order continued from Judge Vareski, continued every day through trial from May 30th to June 12th. Okay, that makes sense. You were trying not to go every day. The day the verdict was given. This is a violation of defendants' due process rights under the 5th and 14th Amendments of the United States Constitution, Article 2, Section 4 of the Arizona Constitution. This alone constitutes a new trial. By the way, remember, she's not talking about it yet, at least, but she kept trying to have him removed with similar claims, and another judge okayed it. So, like, now we have the lack of impartiality. Oh, boy. This one is going to be fun. The court precluded this defendant from presenting her case by not allowing defendant to argue objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents from him prior to cross-examining witnesses. I will say, I can think of one denied sidebar off the top of my head. And if I remember right, she was saying something that was, I think it was either just to harass, I don't know if it was to harass the witness or if it was opening the door. And she kept trying to reiterate the same question. And eventually she said, "Can I have a sidebar?" And he said no, because it was such a cut and dry answer. I can't remember the exact scenario, but I can think of one time that happened. Maybe there was more and they're blending together. This has been a few days at this point. But she definitely was able to cross-examine witnesses, and she argued objections. I mean, they had sidebars, they had the headsets and everything, so she was bad at it. But she did it. To begin, this defendant in attempting to cross-examine the case agent regarding the investigation done at the scene by initial responding officers was denied that opportunity. What? To begin, this defendant attempting to cross-examine the case agent regarding the investigation done at the scene by initial responding officers was denied that opportunity? The initial responding officer spoke with a witness who provided a different description of the Jeep she saw during the incident. The defendant attempted to cross-examine the case agent when the state objected to the answer based on hearsay. The objection by the state was sustained. Yeah. Mind you, she's still going off Jeep colors, right? This is a Jeep where they showed photos in court, and every photo it looked like a different color. I believe the state even brought that up on closing. The objection by the state was sustained. Defendant, even though not having been asked for a response from the judge, argued the statement was not being used for truth of the matter, rather to show effect on listen. Yeah, I remember her saying that. Defendant requested a sidebar and was denied. That might be the exact moment I'm thinking of here, so maybe I was misremembering. No, because I thought maybe it was when she was harassing a witness, but this might be... Yeah, I think I would have considered this in my head harassing the witness. I think she was, like, repeatedly asking about, like, what other people said and kept trying to reword it and got denied by the judge. It was very... There's a lot of that, but it's coming back to me. Yeah, it was... She was so hung up on color. She was more hung up on Jeep color than bamboo shirts, which will make no sense unless you watched her first Arizona trial, where she tried to claim that bamboo shirts were affecting bullets. The same interaction occurred with another scene agent, Detective David Freer, when defendant attempted to cross-examine him regarding what other neighbors told police they heard during a police investigation. A hearsay objection was sustained without allowing defendant an opportunity to respond. Lastly, defendant put on the record early in the case that her investigator, Jeff White, had been out ill. She had nothing but problems with this investigator, at least from my perspective watching the court. It was just complaining about him. The court requested defendant's advisory counsel work with investigator White to obtain documents and exhibits she would need to cross-examine witnesses. Photos were received by advisory counsel and were not able to be printed in time to use the cross of Detective Freer. Those exhibits are attached as Exhibit 1. Well, technically, you represent yourself, so you should have obtained them. And both sides had the time of the case. And remember, Lori is the one that didn't want to delay. The judge kept offering her delays. And then once the trial started, she wanted a delay. Once the jury was being picked, she wanted a delay. Because she wanted a delay to not have the same judge. Defendant also was able to admit Exhibits 129, 193, and 194 as the state and court continued to state she would be opening the door to her prior convictions. Additionally, the state continuously stated defendant's line of questioning relating to Melanie Boudreau constituted a third-party defense. Yet defendant never attempted to blame Melanie Boudreau for her crimes. You fucking did, you goddamn bitch. There is a couple moments where it was very evident you were putting the blame on her. You don't want to admit you were doing that because you like to think yourself as above all that, and she's like a daughter to you. You're like a mother to her. Don't worry, Melanie might... Actually, no. I was going to say, Melanie might end up in the same place, but Lori's going to end up in Idaho, and Melanie, there's an open investigation. I'm assuming she'd be looking at Arizona. So, defendant was simply attempting to cross-examine the victim, Brandon Boudreaux, as to why he blamed defendant. Exhibits 192, 193, and 194 are attached as Exhibit 2. She was also trying to call him gay. If you didn't watch this trial, if you didn't follow this trial, she was trying to randomly just throw in there that he was gay because he was dancing at the Pink Pony, which sounds like maybe a gay club or something, and it's just a restaurant. And he was with some, the story I've gotten, because I didn't do a super dive, was the Pink Pony is a like semi-fancy restaurant. He was with work buddies, and they were drunk. He was the designated driver, and at one point he like danced with them a little bit when they were up excited. And Melanie and Lori were trying to use that to say he was gay, and he believed, according from talking to Charles, the one that Lori had killed, that she was basically plotting to make Melanie think he was gay to force them apart. Denial of Rule 13.5 hearing. On May 29, 2025, after reviewing juror electronic questionnaire, defendant requested a probable cause hearing on aggravating circumstances pursuant to Arizona Rules of Criminal Procedure 13.5a. The court denied the request, stating the defendant was not entitled to a probable cause hearing. Now, they went through this in court where she's not entitled to it for aggravating because the aggravating factors were already in the indictment, I think they said. They weren't adding anything to the indictment, so she doesn't get a hearing. Lori didn't understand and kept repeating, and eventually they just had to move on. Like, she just wasn't listening. This next one here, not releasing the jury from admonition on the record. I haven't read ahead, but I think I remember this. Because I remember thinking it was weird. I don't think I brought it up in my video. The jury was like sent out at one point, and they were not dismissed like in the courtroom itself, I don't think, or at least it wasn't broadcast. After the verdict was read on June 12, 2025, the court dismissed the jury so that the parties could discuss whether an aggravation phase would be presented. After discussion related to the denial of Rule 13.5 hearing, court set a sentencing date and dismissed the parties without bringing the jury back into the room to officially lift the admonition and dismiss the jury. So, I don't know about the process. I don't think that's new trial worthy, but that, I believe, did happen, as far as I can remember. There we go. Allowing GSR and DNA evidence without sufficient foundation. And denial of right to confront witnesses. This ought to be a doozy. On May 3rd, 2025, the state filed a motion to preclude Brady material relating to the crime scene tech, Tammy LeChick, from Gilbert Police Department, who collected material evidence from the alleged crime scene. Brady material shows the witness, LeChick, was implicated in an incident that resulted in her resignation was disclosed by the state on May 1st, 2025, even though the report was concluded on March 6th, 2025. And I believe people in the comments said it was like she got drunk at a hotel and got arrested or something. It wasn't anything related to this case, right? That's the big thing. It had nothing to do with the case, so... Because of the late disclosure, defendant requested the court order the state to disclose the witness, LeChick's employee file, so the defendant could thoroughly investigate any issues that might be relevant to this witness testifying at trial, set to begin May 29, 2025. The court denied this request. May 25th, 2025, the state notified defendant that 2 pages of this witness LeChick's notes, which other forensic scientists would have needed to rely upon or had relied upon, but were now missing, could not be provided to the defense. That's not great. On June 3rd, 2025, in the middle of trial, the state disclosed a letter from the witness LeChick indicating she would not be testifying. Defendant Exhibit 203 marked for appellate purposes. I remember that being mentioned. We don't know what's in the letter, right? We don't know what's in the letter. I do know that whenever they talked about her being on the scene, they also made sure that other people that were there as witnesses talked about watching her gather the evidence. And that would have been her role, so there shouldn't be an issue because it was watched, right? The defendant objected prior to each forensic scientist, 2 from Mesa Crime Lab and 1 from Phoenix Crime Lab, 2 witnesses testifying about analysis they completed based on the work conducted by witness LeChick. Again, the other witnesses on the scene watched her collect it, so... And it was all still in its sealed containers, chain of custody wasn't messed up, it's sounding like it was fine. The first witness was Lynn Sapinoso, who created a profile from the blood clots collected by this witness at the autopsy of Alex Cox. The second analyst was Vanessa Milk, I'm going to mispronounce the Aubrey name, who testified that the blood blot profile of Alex Cox matched DNA swabs taken by witness LeChick from the Jeep Wrangler. Finally, analyst Kyle Mueller, who testified about GSR particles found inside the Jeep that were collected by witness LeChick. Those objections were denied. The Arizona Rules of Criminal Procedure provide that a court may grant a new trial for any other reason not due to the defendant's own fault. The defendant has not received a fair and impartial trial. So now we have the Fourth Amendment violation medical evaluation. A new trial is appropriate if for any other reason not to the defendant's own fault, the defendant has not received a fair and impartial trial, right? By forcing defendant to proceed with trial as her own counsel, deprived her of the right to effective assistance of counsel. I have to reread that. By forcing defendant to proceed with trial as her own counsel, deprived her of the right to effective assistance of counsel. You wanted to represent yourself. You made the decision. In fact, at one point, I believe the judge even offered to hand off. I think it was during jury selection, offered to hand it off. And she was like, is this going to take away my right to represent myself? She wanted to represent herself. There is no honor in forcing this defendant to defend herself sick. There is no honor in ordering by any means necessary to ensure that you will be the judge to preside over this high-profile case. And there it fucking is. She kept lying about illnesses and issues, trying to get this judge removed, the judge that reviewed getting that judge removed. That's all this was. This is Lori's revenge tour. I said this from the beginning. And that revenge tour now includes the judge. That's all this is. The revenge tour includes the judge. She wanted a new judge. She didn't get it. She's going to cause problems. There is no honor in threatening defendant over and over that you will inform the jury that she was convicted of prior murders. You kept referencing things involving your prior cases where you killed your fucking kids. For anyone that didn't watch, Lori wanted to bring up facts that shouldn't have been brought up because they weren't telling people that the jury didn't get to know that she was convicted of conspiracy to murder her husband just recently in Arizona. They didn't get to learn about any of the murders or the cult shit or being dark or any of that stuff that happened in Idaho. They didn't get to learn about any of that. And Lori kept trying to use the fact that the jury didn't know to put doubt. For example, the prosecution had talked about an event, something that happened in Chandler, Arizona in July, I think it was 11th. I can't remember the date right, but anyway, they had to keep referencing it that way, KG, because that is when Alex Cox killed her husband. And they couldn't reference that. So Lori kept trying to weasel around that to try to add doubt. And then she wanted to talk about how she's a great person and everyone knows she's a great person, which is opening up character evidence, which includes her convictions. Again, Lori doesn't want to be held accountable. Where is the honor in this court system? How am I still getting mad at Lori? Okay, let's keep going. Lack of impartiality. A defendant may move for a new trial based on the court's lack of impartiality. Well, under the law, a trial court is presumed to be impartial and free from bias. This defendant can rebut this by the preponderance of the evidence by showing the court required her to be present to present her defense strategy to the state before calling any witnesses. No, Lori, that's not what's going on. Lori wanted to call people to harass them. She wanted to call people who had no purpose to be involved in the case. She did this in the first case, too, in Arizona. She tried to call the journalist Nate Eaton as a witness. He has nothing to do with the crime. He wasn't there. He's a journalist. This was her revenge to her. And she was told, if you can't explain how someone is relevant to the case, they are not going to be a witness. And she couldn't handle it. By denying defendant a thorough opportunity to present her case, by preventing defendant from arguing objections, regularly denying sidebars, and not allowing her... Again, was it regular with denying sidebars? I remember once. Maybe there was twice. Not allowing her time to consult with her investigator and obtain documents from him prior to cross-examining witnesses, this court established a lack of impartiality. Got the window open. Listen. And are attracted to the light. Listen. If your investigator is a problem, you hired him. If you can't handle getting this information, you chose to represent yourself. You chose to not delay the trial. In fact, she had a motion to dismiss, I believe, claiming this trial took too long to start. During cross-examination, defendant was not allowed opportunities or even asked for responses to state's objections. Defendant was continuously admonished not to speak over the court. Yet when courts generally request a response from defense regarding objections, this defendant was not afforded that opportunity. I mean, most of the objections were very cut and dry. Like, if you listen to the trial, it would just be like... Some of the stuff was as relevant as her green chili chicken enchiladas, right? Like, or she would ask the same question over and over and over to a witness. They would give an answer she didn't like, so she'd ask it again and again and again. Or she would ask a question, they would go back and forth, it was denied, she would reword it, and then want to still ask the same question. And then, of course, obviously, she wasn't given that opportunity. When defendant attempted to explain why a statement was not hearsay because it established how the police investigated the case, the court spoke over defendant, telling her the objection was sustained. When defendant requested a sidebar, it was denied. I don't remember this exact situation. Is this the one from prior? Let's see, it's 6:09/2025, minute 30:50:31. Give me 1 second. I'm going to see if I can find it. So I think I found this moment, and it's not really helpful for Lori. It's when a witness was asked about a neighbor talking about a Jeep with a description that didn't match the other descriptions, and it was hearsay, and the same type of argument, I believe, had already been made multiple times, and she wasn't allowed to bring it up. And when she tried to object to the objection, the judge talked over her and said no, and a sidebar got denied, and all of that. I have to imagine it's that. They also say here, by not allowing defendant to question witnesses relating to Melanie Boudreau and how that could have impacted victim Brandon Boudreau's thoughts on why he blamed defendant, this court showed a lack of impartiality. Any attempt to present defendant's case was met with threats of informing the jury about defendant's prior convictions. This is also something I accidentally happened across while reviewing the footage from that court day. This would be from day 3. So what she's probably talking about here is she tried to dive into the fact that Brandon hired a private investigator to track Melanie, which he was doing because he knew what happened to Charles. And yeah, that's something that would open the door, because that's why he was so worried. And as I said, Lori was trying to get doubt put in the jury's mind using the fact the state couldn't mention Charles. Now, by the way, if you haven't watched my video, her Idaho appeal is actually trying to use the fact that they mentioned people like Charles and Brandon. Yeah, so she is trying to play all sides to find a way to keep herself in court so she doesn't have to just live her life in prison without leaving. Let's continue. Abuse of discretion. Denial of Rule 13.5 hearing. The court abused its discretion by denying a probable cause hearing under Rule 13.5 on the aggravating factors alleged by the state. There is only one sentence allowed for the crime of conspiracy to commit first-degree murder, and therefore the state should not have been allowed to argue aggravating factors. That is not how it works, and Lori doesn't like that. The court abuses discretion by denying defendant a Rule 13.5 hearing. Lori didn't want to have aggravating factors because the jury would get to sit there and learn more about Lori, and she wouldn't be able to rebuff it, wouldn't be able to hide behind the fact they don't get to know certain things. She did the same thing in her first Arizona trial. She just stipulated to it so she didn't have to actually watch the jury learn about her in real time. She did it again here and is now trying to use it for a new trial. She's literally basically running away from the jury. That's how I would word it. She literally lost and wants to run. And now she's trying to use her running as an excuse for a new trial. Not releasing the jury from admonition on the record. The court abuses discretion by failing to inform the jury on the record and in front of the parties that they were released from the admonition. I thought it was weird at the time. I don't think it matters in the grand scheme of things. Like, okay, they should have done that. Do you get a whole new trial? How did this affect the outcome? It didn't. Allowing GSR and DNA evidence without sufficient foundation and denial of right to confront witnesses. Finally, by allowing the state to present evidence without a sufficient foundation, this court abuses discretion. Further, this defendant was denied her Sixth Amendment right to confront all witnesses. A clearly material witness was allowed to not be called, and then other analysts were allowed to testify to her work product in violation of Smith v. Arizona and the United States Confrontation Clause. I don't know the specifics of how this works, but as the state made very clear, there were other people present who watched her do all the collections and saw her do it, so isn't it also technically their work product and they're involved? Do you need to have everyone involved in collection? If you have a crime scene and there's 3 people collecting evidence as a team together, but they all touched a different thing, do all 3 have to testify, or is one who was present watching all of the others do it sufficient? I don't know. I'm going to assume Lori is wrong because that has just been the best assumption you can have in general. Further, defendant was precluded from investigating witness LeChick's employee file to see if there were any other issues that would be allowed as impeachment evidence during the trial. Court failed to conduct any evidentiary hearing and they only issued a minute entry stating the events happened after she collected the evidence. By preventing defendant from conducting an independent investigation into witness LeChick and conducting an evidentiary hearing, it abused its discretion. Conclusion, the state of Arizona does not honor the Constitution of the United States. The state of Arizona doesn't honor the constitutional right of the accused or even the civil rights of the accused. For this purpose, a new trial is requested. Respectfully submitted, this 23 June 2025, Lori Daybell. So Lori wants to keep doing her revenge tour. And as I said, one of her targets is this judge. This judge wouldn't recuse himself when she demanded it, and Lori likes to get what she wants. And if you don't give her what she wants or things don't go her way, you happen to get killed by her brother. Yeah. It's a complete mess. Obviously, it's not going to go anywhere, I don't think. Um, her Idaho appeal was better than this, I'll tell you that. Her Idaho appeal, there's some arguments in there that I don't think will work, but I don't think they'll work. But if they end up working, I wouldn't be the most shocked, right? Like, I could see it. There is a non-zero chance. I'll say that, in my opinion. If you haven't watched my video on that, there's some messy things from the state. But Arizona, they kind of locked in, they locked down, they limited things a lot more, and they made sure it was a lot more appeal proof. And what's funny is the fact they tried to make it appeal proof, Lori tried to abuse it at trial to get, some doubt in the jurors' minds, and she failed. So now she's trying to argue she didn't get to do that enough, basically. They kept saying, I might open the door to my prior convictions. That's because you kept mentioning situations involving them. I mean, she was lying by omission to the jury, right? That's what she was doing. She kept lying by omission and purposefully misconstruing what was happening. She wanted to talk about how Brandon hired a private investigator to follow Melanie to make it act like he was some possessive, crazy man following his ex-wife. They don't want you to know that he knew about Charles or any of the other things he found out. She doesn't want you to know that because obviously that makes her look even more guilty. The state can't let them know that because that's bringing in that other case, and then maybe there'll be an appeal off of that. But Lori kept trying to play the gap, and it didn't work out. The judge didn't let her do it. The prosecution didn't let her do it. And honestly, I'm wondering if we're going to be getting another letter, maybe, trying to argue the prosecution did something wrong. Because remember, it's the same prosecution in both cases. She's probably thinking, if I can get a new trial in one case and blame the judge, I can probably argue that for a new trial in the other case. Probably the same with the prosecution. I don't think she's done, but I do think she is out of ideas.